reported today in The Verge. Some of Google's biggest rivals are taking its side in a Supreme Court battle. After nearly a decade, Oracle's copyright lawsuit against Google is close to settling an important question: can you own the basic commands of a coding language? The Supreme Court will reach an answer over the coming months, but a long list of academics, advocacy groups, and businesses, including some of Google's competitors, are urging it to throw out Oracle's claims. Outside groups filed over 24 supporting briefs in Oracle v. Google yesterday, the overwhelming majority arguing that a Google loss would hurt computing as a whole. IBM and Microsoft both filed on behalf of Google, as did the CCIA and the Internet Association, two trade groups that represent a large swathe of the tech industry. A group of 72 intellectual property scholars and 83 computer scientists added their support. Even some less intuitive groups filed briefs, like the Auto Care Association and the printer cartridge company Static Control Components, which are also backing Google. The case's core arguments are well trodden by now. In the mid-OS, Google built its Android operating system with support for Sun Microsystem's Java platform. It avoided licensing Java by largely building its own version of the underlying code, but it couldn't avoid reproducing some lines that were key to the language. When Oracle acquired Sun in 2010, it claimed that Google had violated Java-related patents and copyrights. Google said that these lines comprised a tiny fraction of Android, though, and that they were the only way to let developers write functional code for Java. A court agreed with Google in 2012, permanently removing the patent claims from the case. But Oracle appealed the copyright ruling, and the feud descended into legal purgatory. A federal circuit court, known for specializing in patent, not copyright, law, declared that Oracle should get a new trial. A new trial ended with another Google win. Oracle appealed the decision, and the same court overturned the ruling again, setting Google up for a potential multi-billion-dollar loss. Beyond the money, experts have warned that a Google loss could harm the whole computing ecosystem. It could allow companies to copyright and restrict the basic software interfaces that let third-party developers work with their platforms. One amicus brief pithily compares these interfaces to the functions on remote control. If they become proprietary, companies could effectively mandate the use of a separate remote control for each device in one's home. That's why companies like Microsoft, which aren't shy about criticizing Google in other areas, have lined up behind it. The current ruling elevates functional code to the same level of copyright protection as the creative expression in a novel, Microsoft writes in its brief. But for more on this story, visit the news article link.